Mr. Domina, good morning again.
Thank you. I'm here on behalf of the Lesiak family.
Lesiak.
At least that's how I've learned to pronounce it, and I'm not certain I'm entirely correct about that, but I'm going to stay with it through this morning. It served me well, at least this far, except in terms of the outcome below. Your Honors, I'd like to explain, if I could, a couple of documents that I think will let you understand the facts quickly and let us get to the legal issues presented here. The first document, and I don't know how to manipulate this item to get a little better view, but I think it's okay there. I'll leave it. I think that's okay. I should have asked you before we started. Okay. Well, that'll give me size. That'll help. Thank you very much. This document is the label of the Guardsman Max herbicide product involved in this case. And that product is not claimed to have been defective. So Ohio and National Crane and Hilt, which you just heard about, are not at issue in terms of a product claim in this case. The label is very much central to the issues. The label says that the application rate of this herbicide is determined in significant measure by the soil texture. If the soil is coarse, less herbicide is to be applied. In this case, coarse soils were involved. We know that from the defendant's documents, which expressly describe the soil textures as coarse. The theory of this case, the claim in the case, is an injury to crop on 16 fields. The theory of the case, the primary theory, was negligence. We contend that CVA applied an excessive rate of chemical because the soils were predominantly coarse. A second theory pled was breach of warranty. Before trial, a motion for summary judgment was made, and the trial court issued an order. It clarified that order when counsel for both sides submitted jury instructions. The plaintiff submitted negligence instructions. The defense submitted instructions under breach of implied warranty. The trial court clarified, saying, I intended to dismiss only the negligence theory, which brings us to our first assignment of error. The first error we contend that was made by the trial court here when summary judgment was granted on the negligence theory. Section 251330 of the statutes, in the very first sentence of our sequence of statutes on summary judgment, permits summary judgment to be entered on claims, but not on theories. That became a particularly acute problem here because at the instant when the trial court decided that we could not proceed on our negligence theory, we were left only with a warranty theory. And by that stage in the case, we no longer made any claim that the product was defective.
But if the court determines that a particular alternative legal theory is a matter of law not viable, what prevents it from entering a partial summary judgment as to that theory?
Well, I think, Your Honor, the answer to that is that our statutes permit the court to decide facts that negate proceeding on that theory. I think that the trial court can conclude that that theory of law is one that doesn't apply to the case and dismiss it now under Rule 12. But I don't think the summary judgment statutes, even if only by legislative accident or mistake, don't reach it. Most of the time, a partial summary judgment that clarifies the issues that way is helpful to both sides and to this court. In this case, the problem, I think, is acute because it put us in a position where essentially what we were confronted with was 3 days of trial, knowing we had to have a directed verdict coming because we couldn't make the elements of proof on a warranty theory. We didn't contend the product was defective.
Was the measure of damages the same under your negligence and warranty theories?
Yes. And I think that led the trial court to conclude that a way to get what maybe the trial judge recognized by then had been a mistake on the decision on negligence, to get the matter before you whole. And so the trial court decided you didn't prove your damages with enough specificity. I take it from those questions I perhaps said enough about the negligence theory, so I'm going to move to the proof of damages. Your Honors, the evidence of damages in this case was about as extensive as a farmer's proof of a loss on a corn crop can be. We had everything from the cropping plan to the planting records to the weather records, including temperature and rainfall. We had the irrigation records. We had the crop report scouting records, if you will. We had all of the harvest records, and the harvest records are, at least to a farm kid, fascinating documents, because they include now these maps made by a computer in the combine during harvest, foot by foot as you go across the field. And the maps describe, with a legend at the top, what the yield is in each and every part of the field, down to, and again, fascinating to a farm kid, less yield at the end where you turn and have end rows. Now, my client, when asked about the accuracy of these maps on cross-examination, said not perfect, plus or minus maybe even as much as 10%. If we had only those maps, we'd have an issue about whether our proof was specific enough.
Did you factor in expenses?
Oh, yes, we did, Your Honor. And the dispute on appeal is about two specific expenses, and they're the cost of drying and the cost of hauling. And our client testified the cost of drying was approximately 2 cents a bushel, and the cost of hauling approximately a dime. So we have evidence on that issue. So the question is, can we shrink the 10% down enough so that the trial court can't conclude, without submitting the case to the jury, that there's too much speculation about whether we proved our damages with enough specificity? This is a lost profits case. And in that connection, what we proved, and what the defense helped us prove with extensive cross-examination, was a field-by-field discussion of whether this field or that field had a few wet acres, had some non-irrigated acres, which are differentiated out very specifically because we've also got the county assessor's records, which describe the acreages irrigated or non-irrigated by the acre, and then the differences in yields on both, and locations where we had a little bit of a crop loss because we had sunflowers or shatter cane or some weed. Field by field 16 times over.
Excuse me, on the field by field, they're all identified as coarse without conflict?
Your Honor, no, there is a conflict in the evidence about how much of the soil in each field is coarse. And in each field, as one would expect, there is some coarse soil and some medium. And as we've discussed with some amusement of ourselves, President Jefferson laid out sections, townships, and ranges, but God made soil, and he didn't put it in sections, townships, and ranges. The predominant soil type is coarse. The requirement is that you apply the herbicide to the dominant soil type. The defense says, well, you ought to only recover for the fraction of the field that's coarse, but you can't farm it that way because the soil doesn't lie in sections, townships, and ranges.
Did the trial court in its order or in a sidebar indicate where you failed in your proof of damages?
We had an extended argument on the motion for directed verdict. Judge Owens went out, read a case, Hahn versus Weber, which was cited to him, came back in and made findings, and his record, as I recall it, notes that we did differentiate between irrigated and non-irrigated. He did not think with enough specificity. We differ with that. We think it got, we did not require mathematical certainty. And he also noted that our client admitted that we had some yield losses in some areas of fields that either were not reached with irrigation, were not irrigated as much as other fields because in one instance there was a breakdown, etc. But, Your Honor, all of those points were described in the evidence for the jury with estimates of yield loss attributable to them. So it was a matter of credibility of our witness and whether we had reached mathematical certainty or reasonable certitude.
Did anybody discuss Pribble versus Coinson, or were any shortcomings were there?
Your Honor, there was no discussion of Pribble versus Coinson, and that is the appellant's counsel's fault at the time of that argument. But it's clear that the concepts in that case were debated before the trial court.
What was a jerk? Never mind.
We request respectfully that you reverse and on remand that we be permitted to try the negligence theory. Thank you.
Thank you.